Today we're going to go over the debate as to whether or not states should be able to declare bankruptcy.
The countries listed are just those who are likely to be involved in national bankruptcy. However, this is a global issue. Specifically with Venezuela, the inflation rate could reportedly escalate to roughly 30,000, with the country also having the lowest minimum salary and the country officially entering into hyperinflation. There are three distinct developed actors involved, the first being intragovernmental holdings, which are a country's domestic federal agencies. Then there are the domestic countries themselves, including China, Japan, and the U.S. And then there are their own domestic citizens who are involved through the use of bonds. It's important to first distinguish any other bankruptcy within a corporation to a national bankruptcy. When a person or business cannot pay their outstanding debts, the bankruptcy process begins with a petition filed by the debtor or on behalf of the creditors. All of the debtor's assets are measured and evaluated, and the assets are used to repay a portion of the outstanding debt. Bankruptcy offers an individual or business a chance to start fresh by forgiving debts that simply cannot be repaid, while offering creditors a chance to obtain some measure of repayment based on the individual's or business's assets available for liquidation. However, when a country fails to pay its creditors in time, it's said to go into default. Sovereign defaults are quite different from business bankruptcies, as it is far harder for creditors to repossess the assets of a sovereign entity than to repossess the assets of a company or individual. Defaulting countries tend to restructure their debt rather than simply refusing to pay. The original value of a bond is therefore reduced, or countries request more time to pay. There are a few key terms which directly refer to a country when it goes through sovereign default. The first being a sovereign credit rating, which is the rating of a country or sovereign entity. And this gives investors insight into the level of risk associated with investing in a particular country, including its political risk, and therefore sovereign credit risk. Debt restructuring was difficult enough in the 1980s, when you could bring the holders of most of a country's debt together simply by gathering 15 bankers around a table. This has become more difficult with countries increasingly borrowing by issuing bonds as well as turning to banks. Bondholders are now more numerous, anonymous, and difficult to coordinate, increasing the collective action problem. The resulting expectation that restructuring is likely to prove difficult and disorderly means that creditors may scramble to get their money back in an attempt to beat others to it. Another obstacle to orderly restructuring has been the growing threat of legal action. In part, this is because bondholders seeking repayment do not have to share the proceeds of litigation with other creditors, as banks have to do. A second reason is that litigants have recently overcome one of the traditional barriers to suing debtor governments, namely the difficulty of locating and seizing their assets. In one recent case, a vulture fund in effect held Peru to ransom by persuading courts in the U.S. and Europe to prevent it servicing its debts to other creditors. This is why it may be beneficial to look to corporate bankruptcy regimes for inspiration. Firstly, they offer a better set of incentives to be put in place by creating a predictable legal framework that would in all probability rarely need to be activated. The country would also have legal protection from its creditors for a fixed period while it negotiates a restructuring. Benefits would be considerable for creditors, as uncertainty in regard to the restructuring process would be removed, and the value of their claims on an emerging market country would hold up much better if it runs into economic trouble. It could also help countries with good policy secure more capital more cheaply and increase the efficiency and stability of the global financial system. However, implementing national bankruptcy would be difficult to achieve, as they would need the force of law throughout the world. Also, based on the faith in the market system that the developed world puts, it would make it difficult for potential litigation to be implemented. In regard to the market system, disputes have generally been resolved by bargaining between the debtors and the creditors. For example, Greece, when it negotiated with the EU for bailouts. There are two major impacts on the global political economy if states had the ability to declare bankruptcy. The first being bankruptcy laws would provide the ground rules for creditor-debtor bargaining, thereby promoting efficiency and fairness. This would therefore put a limit on the extent to which one democratic government can bind its successors and bind the countries which owe it money.